So the federal law which prohibits nonviolent felons from possessing firearms is once again up for review after the Supreme Court's recent 8-1 decision and their GVR. So let's talk about what happened during this hearing and what the outcome will likely be. Now, really quick before we jump into this video, I want to ask you guys for a favor. Looking at my analytics, about 60% of my viewers are not actually subscribed to the channel. So just if you find value in this video, subscribe or share this video around. And then also just double check to make sure you have not been unsubscribed by YouTube, because YouTube likes to unsubscribe people. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee makes amazing coffee. They're huge Second Amendment supporters. They have dedicated roasts for organizations like FBC, GOA, and others. So check them out if you want amazing coffee. Links will be down below. I would love for you guys to support that company. A friend of mine owns it. And then also, if you use the code ARMSCHOLAR, you can get 10% off of your orders. Now, as I mentioned in the intro, in this video, we're going to be discussing a huge Second Amendment case that the Supreme Court recently granted, vacated, and remanded, or GVR'd, after an 8-1 decision in a different case called Rahimi. The case we're going to be talking about in this video is the Range versus Garland case, and recently it has been reheard this morning actually in the Third Circuit Court of Appeals, the en banc panel. And the Third Circuit there had a rehearing and is going to issue a new decision on this issue in light of what the Supreme Court just said in Rahimi. This Range case involves a challenge to the federal laws which prohibit someone who has a nonviolent felony from being able to own, possess, or essentially get firearms, and essentially the lifetime ban that is currently on nonviolent felonies. And this morning, like I said, the Third Circuit heard oral arguments. They had a hearing on whether or not they're going to uphold what they said before, if they're going to find that the nonviolent felony restrictions are in fact unconstitutional, or are they going to change their decision. So we need to talk about what happened during this hearing and then talk about what I think the outcome of this case is going to be. Now, for those not aware, this Range case involves the issue of an individual losing his two-way rights under the federal laws essentially forever because of one nonviolent felony. So essentially 26 years ago, the individual here, Mr. Brian Range, was convicted of concealing some of his income so that he could obtain additional food stamps for his family. Essentially, he simply made a false statement on a government form, on a form there. He lied about the level of his income, how much money he had, so that he could acquire food stamps. And because of that one lie on one form, he has been barred essentially forever from being able to own, possess, or acquire any new firearms. Mr. Range brought this lawsuit originally before a district court in Pennsylvania against the Attorney General and the ATF. Essentially, he sought for the federal government to no longer be able to bar him from possessing firearms only because of that one nonviolent felony that happened 26 years ago. However, on review, the federal district court ruled in favor of the government and they issued a motion for summary judgment. Now, after losing at that lower court level, at the district court level, Mr. Range then appealed up to the Third Circuit, and a 3-judge panel in the Third Circuit issued an opinion upholding what the lower court said. Well, Mr. Range did not quit after he even lost there, so then he sought en banc panel review in the Third Circuit. And on review, the en banc panel in the Third Circuit found that this section 922G1 as applied to Mr. Range and his facts specifically are in fact unconstitutional. Now, in that decision, the majority discussed how their precedent had incorrectly used the two-step approach that was rejected by Bruin. The panel also rejected the government's claims that Mr. Range is not part of the people mentioned by the text of the Second Amendment. The Third Circuit Court found that Mr. Range is part of the people protected by the Second Amendment, and his desire to possess firearms for self-defense is in fact conduct that is also protected by the Second Amendment. Now, at that point, the government decided to then go to the Supreme Court and seek review of this case. And like I mentioned, this then sat at the Supreme Court level. Now, after the Supreme Court issued the Rahimi decision, they decided to grant, vacate, and remand the Range case back down to the Third Circuit en banc panel for a new decision in light of Rahimi, and that's what happened today. So let's talk about what happened during the hearing today. What are the main points and the main arguments that were brought up? And then I will give you my guess on what I think the outcome of this case is going to be. Now, first, one of the judges asked questions about whether this case should even move forward, should it be thrown out, because the judge here believes that Mr. Range has not alleged that he wants to buy a specific gun that the judge believes has traveled through interstate commerce. So the judge here is trying to use the Commerce Clause to say, hey, this is not a valid lawsuit, this should not even be here. And really all this signals is it's a pretty weak attempt by this specific judge to want to wiggle out of actually addressing this issue. Now, remember, this is the en banc panel in the Third Circuit. There are a ton of judges on the en banc panel. So all this signals is that maybe one liberal judge doesn't want to address this and is trying to find an easy way out. But it seemed like all the other judges pretty much rejected that. Now, really during the hearing, the main thrust of everything that went on was about the court essentially grilling the government and their attorney about what they consider to be something that is a disqualifying felony, essentially who gets to decide that, and is there even historical support for a lifetime disarmament based on a felony. One of the judges asked the government what they considered to be a serious crime that would actually rise to the level of requiring a lifetime ban on the possession, purchase, or acquisition or transfer of firearms. And essentially, the government's attorney responded by saying that simply anything that the legislator decides is a felony qualifies, and then you would lose your 2A rights. One of the judges, Judge Porter, responded to that by asking, well, what if the government here made jaywalking a felony? What if they made not returning a library book back to the library a felony? Would that be conduct that the state here, that the government here would say would qualify to essentially have you lose your rights to firearms forever? Would that qualify as conduct that you should have a lifetime ban? And the government's attorney said, well, yes, that would qualify, because if the legislator made jaywalking or not returning a library book a felony, all it has to be is a felony for you to lose your rights. And I think a lot of the judges there were surprised by that answer. They did not like that answer, and there was a ton of pushback against that. Now, there was also a section there where the government's attorney tried to push back against the notion that this federal law amounts to a lifetime ban or a permanent ban on your 2A rights. Instead, the government tried to frame this as simply it's an indefinite ban. There's no determined time. It's not a lifetime ban. It's not a permanent ban. But really, that was the government here trying to play semantics, and I don't think anyone on the court really bought that, other than that one judge who was concerned about interstate commerce. Really, the government's entire argument during this hearing can be amounted to that the Second Amendment does not protect people who commit serious crimes. And really, the government here says that all felonies qualify as serious crimes, and because of that, the government can disarm all felons. But there was a lot of pushback against that because a lot of the judges had concerns about all the power being in the government getting to say what is a felony, and essentially at a snap of a finger, all of a sudden everybody losing their 2A rights just because the government says so. And then there was a very interesting back and forth between one of the judges and the attorney there about whether Mr. Range's specific act means he loses his 2A rights forever. The judge asked the government if, based on what Mr. Range did specifically, if he posed a credible threat to other people's safety to the point where he needed to be disarmed forever. And the government's attorney responded by saying, well, Congress determined that people with these types of felonies pose a serious risk, that people with felonies pose a serious risk, and therefore, yes, he can be disarmed. Now, the government's attorney also kind of tried to avoid answering anything specific about Mr. Range and his specific situation about the food stamps, and whether or not he could be disarmed based on just lying on a form. And the judge actually tried to call out the government here saying, well, why are you trying to avoid addressing Mr. Range's specific conviction? Because that's what's at issue here in this as-applied challenge. Because remember, this is a lawsuit that's as applied specifically to Mr. Range and his specific issue. And so, of course, those facts and his situation are very relevant for this hearing, but the government did not want to address that because it really just shines a huge light on how ridiculous these federal laws are. So those are some of the main things that stuck out to me during these arguments. I think those are some of the main topics that I think you guys should know about that were brought up during these hearings. My prediction all along is that the en banc panel here in the Third Circuit would rule once again in Mr. Range's favor. They already ruled in his favor once before, even before this got to the Supreme Court, before it was GVR'd, before Rahimi. And I don't think the Rahimi case really is going to change the outcome of this specific case at all. In fact, a lot of us were kind of perplexed by the fact that the Supreme Court sent this back down to the Third Circuit, because I think we all predicted that the Third Circuit is just going to rule the same way once again in the Range case. And when you listen to the questions and listen to this hearing, I think it signals that the Third Circuit is just going to rule the same way. I don't think that there's much hope for the government here. And eventually this case, I think, is bound to get back to the Supreme Court on a final merits. And maybe at that time, the Supreme Court will decide if they want to address this. So again, that's just a quick summary of the hearings. That's kind of the main takeaways. That's where I think this is going to end up. If you guys have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.